You're listening to WSTU Stuart.
This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. This is Stuart Address, and you are listening to Ask a Lawyer for June 18th, 2021, with Father's Day upcoming, just 2 days away. Well, we have been discussing or trying to discuss for several weeks the conclusion about certain provisions you might expect to see in a severance agreement. And we may yet get back to that today, I don't know. But I once again want to emphasize, ask a lawyer from a couple of things that have occurred in my office this week, because they're illustrative. Now, after we do that, I'm going to try to bring up a new topic, which we've been getting a number of calls about, and that is, can your employer require you to show proof of vaccination or require you to get tested for COVID-19 as a condition of allowing you to return to work or remain on the job? So we'll see what happens. And if we get to that topic today, I think we will.
You can have a vaccination detector at your front door if you're an employer, right?
What is a vaccination detector?
Well, it's like a metal detector, you know.
Well, I don't know. If it detects medical information, it might violate HIPAA. We'll see.
Well, that's like everything else. It's made in China, so it probably would.
You sure it's made in China and not Russia?
Well, maybe that too.
It might have some other attributes to it that we don't know. All right, so this week, one of the calls that I received had to do with wage and hour, minimum wage, hourly wage, overtime, and the classification of whether you are an employee or an independent contractor. Now, we have gone over these many times on this show, and so I don't intend to go through all the factors again. But I do want to present sort of what happened and what some of the key considerations are. Whether or not your employer tries to classify you as an independent contractor instead of an employee is important. First of all, if you're an independent contractor, you're going to be responsible for your own employment taxes, Social Security and Medicare, instead of the employer having to pay half of them. And that's one of the reasons you as an employee may often be misclassified as an independent contractor. So that the employer can try to save that 7.65% that it's going to have to pay for Social Security and Medicare. And some employers just make mistakes. So, you know, it really comes down to the extent of control that the employer has over what you do, when you do it, and how you do it, and whose tools do you use. The more you have control over these things, the more likely you're an independent contractor. The more the employer has control, the more likely you're an employee. Now, whether you're misclassified or you're properly classified and the employer might fail to properly pay you minimum wage or the hourly wage you were promised or overtime, These are governed by two different statutes. First is a federal statute, the Fair Labor Standards Act, and that is administered by the Department of Labor. The second is Florida Statute 448.110. They are slightly different. And so you have some rights under federal law that you don't under state law, and you actually have some rights under state law that you don't under federal law, which is why if I pursue a wage claim, I am generally pursuing it under both the federal and the state statute, so that you have the maximum opportunities for relief. Now, just a couple of key differences. The Florida statute actually gives your employer very little time to pay you from the time you give notice of your belief that you have been mispaid. And if the employer doesn't pay it in this very short period of time, there are significant consequences. So the statute provides that you must give notice to your employer, or your attorney generally must give notice to your employer of your belief that you have been not paid the minimum wage and the amount of the wages you believe you have not been paid. And then your employer has 15 days, 15 days from receipt of that notification to pay you the minimum wage that you are still owed, or come to some agreement with you. Otherwise, you may file suit, and if you win, you're going to get double the minimum wage that you're entitled to, plus attorney's fees and costs. That puts a real burden on the employer once they get that notice. And I'm again hearing on Facebook Live some issues of volume. And so let me just suggest, go to WPSL.com and you could listen to the live broadcast, the audio, directly from WPSL.com. And if you want, you can still watch on Facebook Live. All right, and
I got a question. Despite the pandemic, that 15 days is firm?
That 15 days is firm. It is a statutory requirement, and the employer has to abide by it or risk the double damages, the fees, and the costs. Now, the minimum wage in Florida right now is $8.56 an hour. The minimum wage under federal law is $7.25 an hour. Okay, I see Greg is a little bit confused.
Yeah, they raised it to 15, right?
No. Who raised it to 15?
I thought the feds did.
Well, their goal is to get there, but we're not there yet. We're at 7.25. So if you are fortunate enough to live in the great old state of Florida, you've got to be paid $8.56. If your employer doesn't do that and you sue under state law, this 15-day notice period applies and you can get your $8.56. But if you also sue under federal law, which I recommend, if you win, you're going to get the greater of either the state law statute, $8.56, or why would you want the $7.25 under federal law? Well, you wouldn't. But you might want some of the other benefits that federal law has. For example, the overtime benefits are greater, and the likelihood of getting fees and costs are greater just from experience, not what it says in the statute, but from experience of judges being willing to grant and the extent to which they grant these things. And so you sue under both. Now, The next part of the key difference, or not really a difference, but an important thing that you should know as an employee. Sharon, go to WPSL.com for the audio. That's from a Facebook Live issue. There is, I get calls a lot, and this week I did, about, well, you know, I had to sleep at my office and cover a night shift. Do they have to pay me for the whole night? Or I was on call for 24 hours. Do they have to pay me? Or I was on call for the weekend. Do they have to pay me? These are great questions. That's why you ask a lawyer. So let me give you some of the basics. And folks, you have more specific questions or questions on other topics? Call in right now. We're live. 772-340-1590. And since on radio they always like to repeat themselves, that's 772-340-1590. All right. Under the Department of Labor's guidance and case law, there is something called, are you engaged to wait while you're on call? Or are you waiting to be engaged while on call? Notice the reversal of the terms. It's important because if you are engaged to wait, you have to be paid for those on-call hours. If you are waiting to be engaged, you don't need to be paid for those on-call hours. The key factor, there are a lot of factors, but the key factor is where you are required to be on call and the extent of your ability to perform personal tasks during this time. So, the distinction is important. The distinction determines the employer's obligation either to pay you or not to pay you. So let's look at some examples as to how do we figure out whether you are engaged to wait or you're waiting to be engaged. Look at some examples. You're on call. You have to remain at the employer's premises. All right. When might that happen? Let's look for an example. Hold on one second. I actually have to. I'm sorry. I had to deal with my insulin pump for a moment. It was vibrating and I just had to deal with her. It was annoying me the whole show.
Well, I'm glad the insulin pump is listening.
Right, it's listening and it has no problems with that. All right. So you're on call and you have to be at work. Well, a great example is a firefighter. A firefighter might be on call and have to remain at the fire station, and he or she must be paid the entire on-call period, except for an uninterrupted period of sleep, not to exceed 8 hours, or a minimum of sleep, which is uninterrupted, of 5 hours. So, firefighter is sitting there playing cards, having donuts, cooking dinner. I hear firefighters are really good at cooking dinner. Waiting to jump down that pole, which in my younger days might have been fun, but in my older days would terrify me. They have to be paid for that on-call period. Now, what about you? You are required to spend a day or a weekend at work. You're a nurse. You're asked to spend the weekend at the hospital, not necessarily doing anything, but you just need to be there just in case. You are engaged to wait. Why? Well, because you're being forced to refrain from the freedom of movement and the ability to engage in personal tasks, whether that's doing your laundry, going to grandma's house, or seeing a Marlins game. So the employer has to compensate you. Now, what if you are on call at home? A lot of employees are told, you're on call this weekend. And they have certain requirements. You have to be available within 30 minutes, let's say. Well, the test here comes down to whether you are free to do anything you want except to be available within a reasonable period of time, or whether you are essentially hostage at home because you need to be available on 5 minutes notice. The more you are free to do whatever it is you like, the more likely you are waiting to be engaged. The less freedom you have, the more restrictions which are placed upon you, the more likely you are engaged to wait. If you're waiting to be engaged, you don't have to be paid except for the time you actually work. If you are engaged to wait, you must be paid for all of that on-call time. Look at another example. During on-call, you're required to sleep at your employer's location. Again, perhaps like a firefighter or a nurse. And there are other instances where people have to spend the night. Well, if you are on call for less than a 24-hour period and your employer requires you to spend the night and provides sleeping accommodations, you likely must be paid for sleep. That's right. You have to be paid while you're dreaming and counting the millions that you hope to achieve one day.
Yeah, the technical unions in television news call that golden time.
Well, it certainly is golden time, because if I can be paid to sleep, well, sometimes I can't. Sometimes I think I should be paid to sleep. Sometimes I sleep and I'm either dreaming about a case or I wake up in the middle of the night with an idea fully formed and I jump out of bed and take some notes or something. Now, I can't charge the client for the sleep time. I wish I could, but I can charge the client for the time after I've jumped out of bed and taken some notes, and I do.
So how much sleep do you get when you're working on a summation?
When I'm working on something, whether it's a summation or a trial, or I have something right now that I'm working on, I can't really explain for confidentiality purposes, but it is something that it's going to result in a 20-page legal memorandum. There is a deadline, and it is almost the only thing that occupies my mind right now. And so I come up with ideas at odd times. It could be while I'm sleeping. It could be while I'm on the toilet, or as Archie Bunker used to call it, the turlet. And the client's going to get billed for that time, let me tell you, because I'm actually working. I am forming an argument. I'm forming ideas to research. And so, well, we've sort of gotten a little afield, but if you have to sleep at your employer's location, for less than a 24-hour period, and they provide the sleeping accommodations, they likely have to pay you for the sleeping time.
So do you have legal tablets in every room of your house?
Well, I almost don't go anywhere without my iPhone and my iPad. So my availability to take notes is very close to my fingertips.
Okay, next dumb question. You talk about your iPhone and your iPad.
No, I don't have an iWatch.
Are legal tablets a thing of the past? Or is everything
Oh,
going to be on a
you mean
tablet?
legal pads? Like
Yeah.
yellow pads? No. I have a bunch of yellow pads right within reach of my left hand here on my desk. They are not a thing of the past. I use them to take notes all the time, to scratch out notes. I don't use them to draft. When I'm drafting, I will preferably be on my laptop or pull out my iPad, which is larger with my big, thick, fat fingers, and I will type away. Or I will dictate in and get Siri to say the weirdest things that I didn't mean to say, but in context, I can figure it out. So I allow her to say intercourse when I said during the course. When I read it back, I can sort of figure out what I really meant. Because if I tried to stop to correct everything, I would lose the train of thought that I'm under. And sometimes in your mind, for those of you who don't know what goes on in an attorney's brain, many of you think nothing. But if I'm really thinking about, let's say, a research project or an argument or something, I may have several of these balls jumping in my brain, juggling, and I'm not a good juggler. And I need to get it out somehow. And if somebody interrupts me, like my son or my fiance or anybody else, trying to get my attention, I have to rudely shoo them away. Because if I even stop to say, I'm busy, I can't talk right now, some of those balls may drop. And I have had to explain myself to several people that I didn't mean to be rude, but this happens when I'm really engaged in some complicated thinking. I just can't be bothered to be polite and say, please give me a few minutes. I've just got to hold up that hand as a stop sign, and people get really pissed off.
In other words, you couldn't have me working in your same office then.
You know, Greg, you would probably drive me to drinking. I'm not a drinker.
Well, I've done that to several people.
Okay, so now what happens if you are on call for more than 24 hours? Well, the same rules are true, except if you're on call for more than 24 hours, you and the employer may agree that sleep time is not compensable, with the employer being allowed to take a credit for a maximum of 8 hours per day for sleep time, except if your sleep time is interrupted, then unless you get at least 5 hours of uninterrupted sleep, you have to be paid. Why would you agree to this if otherwise the employer has to pay you? Well, the reason is the same as you would agree to any other term the employer proffers to you. Because if the employer says, this needs to be our arrangement or you're not getting the job, that's perfectly legal. If the employer says, this needs to be our arrangement or you're going to be fired, that's perfectly legal. Now, the employer can't say, well, it was so nice of you to spend the week here sleeping overnight. This needs to be our arrangement, and you're not going to get paid for this past week unless you agree. That's not okay. The employer is always allowed to seek to change the terms and conditions of your employment for the future. the employer cannot unilaterally change the terms and conditions of your employment for the past. So these are the rules going forward, and whether or not you are an employee or an independent contractor, whether or not you are waiting to be engaged or engaged to wait, these are complicated issues. And that's why you need to ask a lawyer, preferably earlier rather than later. And I will say, before Greg says, I can see he wants to say something, but before he does, I will say, I'm a little surprised that there aren't any of you out there listening that don't have issues like this relating to your payment or what is owed or being paid to you as an employee, and aren't giving us a call now at 772-340-1590. Because I get so many calls on this that I can't believe none of you have any questions.
Well, they may be taking copious notes.
Well, and if that's the case and they're taking copious notes, you can always give us a call at my office, and that's 772-781-8003. Operators are standing by. Well, that's not precisely true, but
At 3 a.m.
if you leave a voicemail, we will get back to you. And voicemail is becoming more common these days. And I'll be honest, I've said this on here. Since the pandemic started, I've begun to work from home more and more often. And very often the calls aren't automatically transferred, or I'm working on something and I, don't want the calls, or paralegal is or is not in the office. So you might get our voicemail. I know that, some people find that frustrating, and I can understand that. But please leave us a message. The messages come to me immediately by email, and we try to get back to you as soon as possible. We really do. It's something I pride myself on. So let's go into the second type of call I got this week before we try to get to the COVID stuff. And that is, I got a call from an employee, a lovely lady. I enjoyed speaking with her, and she was crying at times on the phone, and I truly felt for her, and I'm still trying to find a way to help her. But she shot herself in the foot, figuratively speaking. She didn't do a Cheney. For those of you who can't remember or are too young, Dick Cheney, former vice president, shot somebody while on a hunting trip. Anyway, she calls, and she had trouble at work. There was some discrimination going on. It sounded like it might have been age-related, with a bunch of younger women in her area of the office that were sarcastic and nasty with her about her age. It seemed like some of it might have been sexual harassment, with pictures shown to her of these supposedly very large dongs that certain types of males apparently possess, and her expression of distaste and believing it was inappropriate, especially in the workplace. And ultimately, she did the right thing. She complained to Human Resources. And apparently, Human Resources did the right thing. They investigated, tried to take prompt remedial action, spoke to those co-employees, and for a period of time, things improved. Then went back to normal. She was seriously very traumatized by a lot of these sexual oriented comments, not so much by the age stuff, but by the sex stuff. And she resigned. And then she called me. And ask a lawyer. Ask a lawyer as soon as you can. What harm is there in calling a lawyer or two or three and seeing if you can get some instruction, some advice for free? We'll give you some of that. And if it becomes a little bit more detailed, then depending upon the type of matter, we'll offer you an hour's consultation. On this type of thing, it would have been a free consultation. On other types of matters, it might be a paid consultation, and you can choose to say yes or no. But at least ask a lawyer. Try. If you've got one in your family, the third cousin twice removed, call them. Ask somebody who's been trained, even if they're not an employment attorney. Although it's much better if you do check with an employment attorney. Because here's the problem. If she had called me when the retaliation first began, I could have improved her prospects of remaining on the job, or at least improved her prospects in any future litigation. Now, how could I have done that? Well, one example is I could have drafted an email for her that she would send under her own quote unquote signature, appropriately warning the employer of her rights under Title VII of the Civil Rights Act and under the Florida Civil Rights Act, indicating that the employer needed to investigate and take prompt remedial action. And it would have been in writing and much better enhanced any future litigation. Now, when the retaliation started, or the discrimination continued, as in her case, before it got so bad that she felt the necessity of resigning, if she had called me, and I told her this gently, I could have again tried to protect her job, or at least classify her resignation as a constructive termination, a constructive firing, because of the stress in the hostile work environment. And that had all sorts of implications, whether you resign or you're fired, not the least of which is the ability to get unemployment. But it has far more implications in your lawsuit. And so her having resigned already, without even putting in writing why, seriously harmed her prospects in any future litigation. Because what's the employer going to say? We didn't know. If only we had known, we would have told her not to resign, and we were going to try to fix it again. And if I was sitting on the jury, I might believe that, especially if I heard that she had originally gone to HR and they had done the proper thing and it had been fixed for a period of time. So her failure to have done that when it reoccurred, I might find in favor of the employer as a juror. And so you've got to please ask a lawyer when you think something might be amiss. Now, I often get the response, well, I'm a layman. How am I supposed to know it's wrong? Well, you're not. That's why you ask a lawyer. If you all of a sudden find a big, ugly mole on your face with hair growing out of it, I think you're going to ask a doctor. You're not going to ask your beautician. And asking a doctor makes a lot of sense. I mean, my knee was acting up. I was finding that, after I slept, if my knee was crossed, my leg was crossed, there was a lot of pain in straightening out my leg. So what did I do? Yesterday, I was at my orthopedist, and he gave me a shot of cortisone. I asked the doctor. He gave me his advice, which I knew he would, because I've had it before. And I got the medicine I needed. If something is going on in your workplace, I'm an employment attorney. If something is going on in your workplace that you think is odd or inappropriate, and you don't know whether it's unlawful, just ask a lawyer. You don't have to ask me. That's not the purpose of this show. I'd love it if you called me now or at my office, but you don't have to call me. Call anybody. Call anybody with a legal degree and who's admitted to the bar to practice law. At least check it out.
Could you have checked, at least maybe talked it over with her ex-employer, I guess now, and see if they could improve the working conditions, or is that out of the question?
No, actually, I am trying to find a way, despite the resignation, to at least do a demand letter to the employer. And this is my job when I am hired to be your mouthpiece, notwithstanding the fact that she resigned. I take the facts that she gives me and I try to present them in the best favorable light to her. It doesn't have to be something that would win in court, but for a demand letter, I can try to take it and write a pretty good demand letter, try to cause fear in the employer about the prospects of future litigation, and see if I can get her a severance agreement where she releases all potential claims against the employer. And that's what we're looking at now. She is in the process of sending me emails that she is looking for, where she did give some notice of what was going on, because then I can work with some writings. All right, and I can argue at least to the employer, you should have done more, you should have checked on it. And when she resigned, you should have at least asked what was going on. Is this the result of anything that you had been complaining about? And that's hopefully what I can do for her. And we do have John on line 1. Hello, John.
Good morning, Counselor. Good morning.
Good morning.
I have a question. I have a difficult tongue twister, and it's okay if you don't know the answer. But
all right.
Are you familiar with government entities that own real estate? Because this is a zoning question. For instance, the city inherits property, and the property is zoned for multifamily up to 100 units. Do you know anything in the Florida statutes that prohibit them from, I know there's public housing, but besides that, would there be anything from prohibiting them effectuating the property as zoned?
Well, first of all, you're asking about zoning, which is one strike. You're asking about public housing, which is a second strike. But what exactly, John, is the question?
I know government entities can build public housing on public property, but Are they allowed to build anything else on property besides public housing?
Well, I would assume you're talking about a public entity building on public land?
Well, originally it was private land, and they defaulted on the property. It went to the county. The county didn't want it. It went to the city. So right now we're stuck with a PUD that says that it's multifamily 100 units. And my question is, can the city, who owns the property now, effectuate what the zoning is? Meaning,
if they go through the proper procedures to change the zoning, I believe they can. if there is a zoning requirement on that property at the time, it defaulted to their ownership, then I think they're stuck with that zoning unless, like anybody else, they file for a zoning change and there's public notice and comment and a decision properly made under statute to change the zoning. I think they can do that.
Mhm. But as it stands now with the current zoning, they could put up a public housing complex with 100 units. There's nothing stopping a government entity from doing that, correct?
I would not think so if that's how it's zoned. I would think they would be able to build that.
Yeah.
And people would come.
They can't, hire a contractor to put up a private condominium or something.
No, if it is zoned for public housing, they're not going to be able to put up private condominiums. No.
Yeah.
But if Donald Trump wants that property to build $1 million condos and goes through procedures to amend the zoning or get an exemption, and it's properly noticed and properly heard and properly amended, then yeah.
Yeah. Just to clarify, it was never supposed to be public housing. The only reason I mentioned it is government agencies, like I illustrated, can't hire a contractor to build a condominium. They can't use a private entity to create a private entity. But the way it stands now was never meant to be for public housing. It just fell into the city's lap. It was
I hear you.
a property tax sale, tax lien and cheated, whatever. And it was supposed to be multifamily. It was supposed to be
whatever the zoning is, I'm confident it must be abided by, absent a proper application for an exemption or to amend the zoning.
Okay.
Of that, at least, I'm confident. Beyond that, I probably don't have any confidence to speak about zoning.
Okay. Thank you.
All right. Thank you, John, for calling. Thanks for listening. I appreciate your calls weekly.
Yeah, Stuart Attorney, the brand new city attorney for the local city.
Oh, there's a brand new city attorney?
Near you. Oh, no, I'm just joking.
Something, I don't ever want to work for somebody else again. I am at that point in my career where I am not an employee. I got to be the boss. I'm set in my ways. And you want to know something? Here's an interesting arc. I mean, I really want to talk about the COVID, but I can see we might start it, but we won't finish it, which is often what happens with me. It's always what happens with me, let's be honest. But an interesting arc here. When I graduated law school way back in '85, I took a job with a law firm in northern New Jersey that had more than 200 attorneys and was one of the largest law firms in the state of New Jersey at the time. And after a few years, when some associates would typically look to move, I decided to find another position with another firm, and I moved down to South Jersey, and I took a job with a firm that had a little bit more than 100 attorneys, so a little bit smaller, but was the largest law firm south of Princeton. So it was the largest law firm in South Jersey. And then I moved to Florida in late '93. And the first real full-time job I got in Florida was with a firm of about 15 or so attorneys. And I was doing defense work for insurance companies and working for the first time on a Mac, and I couldn't stand it. And there's an interesting story there about me and the partner I worked for, who was mayor of Ormond Beach at the time, like long-term mayor, over and over and over again. And I was the only one in the firm who would yell at him, and his secretary out in front of his door just laughed hysterically because I was the only one who had the nerve to challenge him.
So did he know how to work the Mac?
I didn't know how to work the Mac. I learned the basics, but I could not stand it. I was too bred into Windows. But anyway, after a few years, it became a race. Would I choose to leave and find a new job first, or would he fire me first? Everybody in the firm was taking bets because we would go at it, and he would often tell me, he'd come out and say this: "My wife told me to fire you this weekend, but I can't because I had just won another case." So I would win these cases, and the timing would just be propitious in that he was planning to fire me, about that time. And it was like, I can't fire you right now. So it was a game of what was going to happen first. So I found a position here in Stewart, the position I had. Well, not the position I have, the position I had first. And I go from about 15 attorneys to 2 attorneys. I keep going down, 200, 100, 15, 2. And that was really, that was a great job. That was a great job I had for about a dozen years. I worked with Guy Rubin, Rubin and Rubin. See, I'm giving you a plug, Guy. And it was truly a wonderful working relationship. He would come into my office and bounce off ideas on the cases he worked on. And I would tell him, from a distance, here's where I think you're wrong, or here's where I think this argument should be changed. And I had a different perspective because I wasn't involved in it. And I would go into his office and do the exact same thing. And it was really, really productive, and we did well, and I truly enjoyed it.
So there was synergy there.
There was great synergy, truly. And after about a dozen years, I had my son, and I was offered a partnership, but the partnership documents were like 150 pages long. And let's just say, in shorthand, I was a little bit insulted by the terms. And so I set about looking for another alternative, and I opened up my own practice. So now I went from 2 to 1.
So now, wait a minute, you have a 12-year itch. So you worked 12 years in North Jersey, another 12 in South.
No, I worked, well, overall, I worked 8 years I worked 3 years in North Jersey, 4 years in South Jersey, about 2.5 years in Daytona Beach.
Oh, okay. Yeah.
A dozen years in Stewart, and now I've had my own practice since 2007.
That makes perfect sense.
But I keep saying, if I go any further south, I'm going to be working in Cuba, because I ain't going to Miami. And also, you can't get any lower than 1. The next stop is retirement.
Well, you could always go down with Port St. Lucie Mayor Greg Orbach to Isla Morada, huh?
I sued him once.
Oh, gosh.
I sued him when he was the city manager. I sued him when the mayor was Joanne Fiella.
Oh, no.
And I sued him in the city on behalf of a number of Port St. Lucie police officers who were laid off at the insistence of Mayor Fiella. And the dirty deed was done by City Manager Orbach. And we assert that this was done as a result of their positions in the then recent mayoral campaign and who they sided with. That was a long time ago.
Yep.
So yeah, but anyway, so yeah, I've enjoyed practicing solo, but I will tell you there is one thing I have missed, and I've told this to many people. I have missed having somebody in the office to come in with a fresh perspective and say, I don't think your argument is going to work here. That ability to bounce off ideas with somebody of equal or perhaps superior caliber is truly a valuable thing. And I think probably in most businesses or professions. But in law, I have this great argument I plan on making, and somebody comes in and says, don't you see the hole here that a Mack truck can drive right through? No, I didn't see that. Thank you. And now you fix it. I have utilized my paralegals in that regard. I have had good fortune in having paralegals who either had the experience or as a result of working with me acquired the experience to come in and tell me, you don't know your arse from your elbow. And sometimes that's been very beneficial. I had a paralegal in the middle of a trial yell at me, stop, you need to do this, show this. And I did, and it really helped win a case. So having somebody else is very valuable. Okay, we only have 2 minutes, so clearly we're not going into COVID. So let me give you a preview. Employers are beginning to require vaccinations to come back to work or to remain at work. Some are requiring testing. There are a lot of questions I'm getting. Can they do that? Isn't this medical information that's protected under HIPAA? I'm going to give you a short answer. The short answer is in general, they can do that. Okay? There are some exceptions, but in general, they can do it. We'll talk more about it next week. So have a great weekend. Have a great Father's Day. I got to tell you, I wanted to say something about Father's Day and I forgot, and I don't have time now. I was really proud of something I observed with my son yesterday. So I hope you're all happy, you're all proud, you all have an enjoyable time, and I'll see you next Friday on Ask a Lawyer. Thanks very much.
Happy Father's Day, Stuart.
Thank you very much. I appreciate it. You as well.
Ask a Lawyer right here on WPSL, Port St. Lucie, talking the Treasure Coast, webcaster to the world, and WSTU Stuart, serving Martin County and the entire Treasure Coast since 1954.